So good evening, everyone. I am Venkatramani Lairi, Assistant Professor, DME Law School, and I welcome you all to this webinar on study of law and challenges being organized by the DME Law School, Noida. Today, we are honored to have with us Mr. R. Venkatramani, Senior Advocate, Supreme Court, and member of the Law Commission of India as the chief guest to this event. Sir, though needs no introduction, for the benefit of the audience and the students present here, I would like to give some. Sir has completed over 40 years of practice in Supreme Court, which commenced under the tutelage of Padma Bhushan, late Mr. P.P. Rao. He has served 2 consecutive terms as the member of the Law Commission of India, where he has worked on key reports spanning on issues relating to arbitration law and honor killings. He has been a member of various other commissions and expert groups, such as Justice M.N. Venkatramani Commission, the Equal Opportunities Commission, etc., and has also authored popular books such as Halsbury Laws of India on torts and the Supreme Court Practice and Procedure being a notable few. Sir is also the recipient of the Justice V.R. Krishna Iyer National Award, awarded by the Capital Foundation, which was presented to him by late Dr. Pranab Mukherjee. We are honored to have you here, sir, today, and we welcome you to DME. I would also like to extend a welcome to our Dean, DME Law School, Professor Dr. N.K. Behel, who is with us today at this event. I welcome all the participants, and I'm sure that today's event will help everyone present here in enriching their experience on this theme. So, sir, without further ado, I would invite you to enlighten us on today's theme. Over to you, sir.
Thank you so much, and thank you for this nice warm winter afternoon, but on a virtual screen when the warmth of the sun is not with us. And thanks for the presence of your dean and Mr. Kush and other dignitaries in your institution and your good self. When an invitation came from Mr. Kush, whom I have met a couple of times in few other institutions, I could not certainly resist the invitation. And particularly when it is a matter of talking to students. When you mentioned about my 40 years of experience, every time I keep talking to the students, I keep thinking that with every year of my experience in the profession, I think I should be adding one more chapter of understanding about what law is about and what the study of law means. And I think I try to keep doing that. So if I look back at what I spoke to perhaps the students of law in Bangalore Law School maybe about 25 years ago on a national seminar on changing dimensions of law. And I look back that and then try to visualize as to what exactly the position today. I find there is a considerable leap of events, if you may put it like that. I hope I'm visible and audible.
Yes, sir, very much so, sir.
Okay, all right. So why I want to say that is for a generation of lawyers like me and your deans and the teachers who are in the 60s, late 50s and 60s, the windows opening to the study of law were very different. And look at the vast and sweeping changes that have taken place in the past, let's say 50 years post-independence, not only in India, but all over the world. So if the study of law, maybe not only in our country, in other parts of the world, in the early parts of this century, or the later part of the previous century, but all about looking at the resolution of disputes through a court procedure and studying law from uh, an analysis of judgments and the sparse statutes that are being enacted by parliaments or legislative assemblies. You go back to the year to the late 1700s, after the US adopted the Constitution, and with a famous judgment that the US Supreme Court delivered in Bradbury versus Madison. Everybody says that was a great revolution in judicial thought. In that apex judicial institution of a country gave to itself a power to review whatever the government would like to do, what we in popular legal terminology call judicial review. We will have a peep into all that, but I just wanted to say from then on, the past 200 to 300 years, look at what has happened across the globe and what is the study of law then and what is it today. And why are students, probably inspired or persuaded to become students of law and not students of some other disciplines. See, there's one of the well-known judges in US, called the Judge Richard Posner, who has written extensively on the economic analysis of law, says something like this about law's dependence on history. I quote, he says, law is the most historically oriented, more blankly the most backward looking, the most past dependent of the professions. It venerates traditions, precedent, pedigree, ritual, custom, ancient practices, ancient texts, archaic terminology, but maturity, wisdom, seniority, gerontocracy, and interpretation conceived of as a method of recovering history. It is suspicious of innovations, discontinuities, paradigm shifts, and the energy and the brashness of the youth. These ingrained attitudes are obstacles to those like me who like to reorient law in a more scientific, economic, and pragmatic directions. The very profound words of a judge with more than 30 to 40 years as a judicial officer in the US, venerated the US judicial traditions. You'll pick up any one of his books and find that he has been contributing enormously to both judicial and legal thought. So when he says law is so past dependent, but when he also says, I would like to reorient law in a more scientific, economic, and pragmatic directions, does it make any sense to a country like India? Well, does it make a sense to a country like countries in South America or Africa or any one of the so-called, recently so-called third world countries? Of course, we no longer call any country a third world country today. Maybe a couple of generations ago, the European masters and the US or the imperialistic, colonialistic people thought about third world country. But today there is no third world country. One important reason we'll be soon talking about it. So I wanted to quote him only to tell the students and generally the legal education institutions that while whether law or any study in any branch of knowledge cannot break away from the past, because every branch of knowledge is rooted in the past understanding and traditions of knowledge. But then when just Posner talks about reorienting on a scientific and economic or racial basis, he is telling us something very important for reprogramming the ends of the study of law itself. So I think it needs a very close attention to what he says. I just want to quote another very inspiring quote. I keep quoting it all over again whenever I talk to students, because it makes a lot of sense again in a historic way. So I go back to the year 1780, and this was a statement made by the then President of the United States, John Adams. And he says this: I must study politics and war, that my sons may have liberty to study mathematics and philosophy. Closely watch all this, this sentence. I must study politics and war. That is in 1780. I must study them, that my sons in future, he says, may have liberty to study mathematics and philosophy. To study mathematics and philosophy, you need a leisure and peace, not a war-torn, disorderly, socially society without in disorder. He says, my sons ought to study mathematics and philosophy, geography, natural history, naval architecture, navigation, commerce, and agriculture in order to give their children a right to study painting, poetry, music, architecture, statuary tapestry, and porcelain. So the grandchildren should study something else, not war and politics. So from study of war and politics, which means disputes, to the study of mathematics and philosophy, to the study of poetry, music, architecture, look at the world of difference. So the one world will be a world torn in disorder. The other is a world where peace, social peace, internal peace, individual harmony with the society, all that would prevail. So I think from Posner to John Adams, the study of law will have to be probably a movement away from a study of disputes, politics, and war, to a study of how we create and generate and sustain social harmony, peace, and where our grandchildren, or probably students who are studying law today and listening to me today, would be able to study probably in the later part of the years, more of music and architecture, more of philosophy and mathematics, and more of, as I said, poetry, music, and painting, rather than looking at the conflicts we see today. But that's one grand design which law will have to necessarily draw. If you have to move away from a mere study of law mechanically in the context of court resolving, administration of justice, to a larger tapestry where this study of law will itself be reoriented. Having said that, I would like to just quickly, like a bullet point, look at about 8 to 9 aspects of the study of law in contemporary times. The first is the movement of the law, of the study of law away from the confines of mere domestic frontiers. You go back to 100 years in England, or probably about 75 years in India, and who studied law and for doing what? And what did they study? So from a mere confines of the domestic frontiers to a globalized world. So that is one important shift which has happened. The enormous implications of this shift. Therefore, if you go back again to an early part of study of law in England, you studied the law of contracts or civil wrongs, torts, property, succession, and crimes. But again, from within the narrow scope of, let's say, what Englishmen wanted to go about with their own legal order. So also it happened in all European countries. So also it happened in the Asian nations. So if you look at our own traditions, whether it's on the Manusmriti or thereafter, we have a large treatises looking at, or one may, for instance, briefly recollect, a great rendering called the Raja Tarangani in Kashmir. So we have a large number of treatises in our own country where the relation between law in a very domestic context and administration of justice, etc., had happened. But as I said, the movement away from the narrow domestic confines to a globalized world is a very important shift. The implications will have to be noticed, and they are being noticed. Then, even in that context, so how was the student studying law? Did they go to a law school like what is happening today? Did they have a classroom where teachers are able to assemble all host of materials to be able to share with them? If you can recollect a very important name again in legal education in USA called Christopher Columbus Langdell. So this name is a familiar name because he was one as a dean of the Harvard Law School. He was instrumental in bringing changes in the manner of study of law. One important change he brought about was the case study method. From a mere, looking at the historical, tradition of study of law, the case study method, Langdell thought, will make students more closer to understanding the dynamics of law in practice. But then, even Langdell was only talking about the domestic law of the United States, or for instance, and then very briefly, whether an English lawyer or an American lawyer would have studied the laws of other nations, the legal tradition systems of other countries, is a moot point. So they were studying law again within the narrow domestic frontiers. Then comes a small, say, a shift from an entirely different angle. The study of law remained in isolation from the rest of social theory and practice. You have the emergence in 19th and 20th century, sociology, study of sociology, political ideologies. You have those great thinkers in the European continent, Karl Marx, Emil Durkheim, Max Weber, and so on and so forth, who began to bring into the study of law a connection between the study of political sciences, study of social sciences, and the relevance to study of law and vice versa. And then you see next, around the same time in England, again in Europe, a number of emerging thinkers who wrote on jurisprudence. Jurisprudence, whether it's called Professor Hart or Solomon, the great, the well-known textbook on jurisprudence by Solomon and Holland, and we had other thinkers in France with the French Revolution, who was responsible for a great doctrine called the doctrine of separation of powers, Montesquieu. Then we have the utilitarianism school of thought, the John Stuart Mill, and those students of jurisprudence who are familiar with the concepts of rights, obligations, etc., the American writer called Hoffel. So all of them who are writers and jurisprudence were focusing on, again, within the domestic sphere of law within each respective countries. Of course, there is something called the common law tradition or the civil law tradition. That is not a matter of great importance in the study of law. So we had these political, ideological, social theories coming in, and great thinkers making a difference to the relevance, the relation between law and the rest of social studies. So concomitantly, you will find, again, going back to European, continent, because many things happened in Europe. And apart from whatever happened in the rest of the world in their own way, the thing that happened in Europe had a large-scale implication for both history and law and jurisprudence in the 19th and 20th centuries. And what was that very important thing which happened in Europe is the emergence of the idea of constitution. The emergence of the idea of a constitution is one of the great things which has happened both in European history and much thereafter, even in contemporary times. So a student of law today is introduced to the idea of a constitution, to the study of a constitution, which probably did not happen to a student of law in early 18th, 19th centuries. The study of constitution as a very important, the core study of law was yet to happen in early 19th century. So much later, of course, when the US Supreme Court has begun to be involved in larger social and political resolution issues, the US constitutional history became also the core study in the study of law in USA. So we have the emergence of the idea of a constitution, and then along with the constitution comes two important concepts. One is the idea of democracy, and the more important thing which comes along with it is the rule of law idea. So we have the idea of a constitution, the idea of a democracy, and a very important pillar of the idea of rule of law. So they have close connections. Today, whether you study a statute about a law of contracts or a competition law, whether you study a law relating to marriage, personal law, or you study a law relating to insurance, right? Take any branch of law. You will find these three important pillars, namely that all decision-making procedures by any person, whether it is a government or a statutory authority, a public body, or any person who is invested with an authority under a law will have to act fairly, justly, and reasonably. So where do you get all these ideas of fairness, justness, and reasonableness? And don't you think that is so closely connected with the ideas of rule of law and the idea of a constitution, which means, in my understanding, that all power in a society today, all power in a society, perhaps except communist China or some such countries, all power in a society are subject to regulation, control, and supervision. So whether it is private power or public power, whether I want to enter into a contract with somebody or enter into a trading relationship or set up an industry, okay, it's all my private decisions. Whether I want to dispose of my property or whether I have choices in my personal life, they're all in the realm of private power. So when it comes to public power, whether government should acquire a piece of land or government should arrest somebody for some anti-national activities, so on and so forth, or the government should form a political party and says these political parties should have certain features, certain conditions should be complied with them, or the government says I'm going to take over a religious institution. All these are in public power. So within private power and public power, Constitution says all these powers shall be subject to regulation, control, and supervision. So when you study any branch of law, you will closely find out that you are talking about regulation, control, and supervision. So the regulation, control, and supervision are the three pillars in, again, when you go back to democracy and as well as the idea of a constitution. So with that, we have very important paradigm shifts in the study of law so fundamentally that, and then sometimes it happens so imperceptibly. People have not noticed how it has really happened. For me, as an experience, I'm talking about it, that it has just happened so unnoticeably that the shift from we are looking at a contract law statute and looking at some decided cases to seeing the connection between the law of contract to the principles of fairness and equality is a very important thing which has happened. So I've seen it happening in our own, lifetime and generation. So while the idea of constitution has happened across the globe, and we have another important historical feature which has greatly contributed again to the study of law in contemporary times. And what is that? And that is colonialism. Colonialism has also, like the idea of a constitution, have certain like twin sisters. Colonialism spread because of the expansions of European power across the globe. And with the expansions of colonialism also, the exchange of the respective legal systems. It just happened that because if English, the French and the Dutch traveled all over Asia and then Africa, so you will find the kingdoms both mostly in Africa and Asia. But unlike them, maybe other parts of the European kingdom, Germans, Russians, did not have colonial empire. If they had done that, it would have been a different historical thing for us to say. And because English and French and Dutch people came all over the world, you find the English legal system and the continental civil legal system to some extent have been transported to the rest of the world. So two things were transported. One, the common law English tradition and the civil law legal system, as well as the ideas of constitutions and the parliamentary sovereignty as the process through which laws should be made and how democracy will prevail. So colonialism contributed to some of the very important transplantation of political ideologies and social and legal jurisprudential ideas. And then comes later, after the World War I and II, we have one important development, namely the emergence of a world-level organization called the United Nations. With the United Nations, what has happened is, from the point of view of students of law, is what has happened is we have a whole range of human rights, developments taking place. The United Nations Declaration of 1948 onwards, we have large number of, the past 20 to 30 years, large number of international legal instruments, whether they are treaties, whether they are covenants or conventions or declarations by United Nations, or any one of them. So that is another chapter in world history which has begun to impact study of law, which has moved away from mere confines of domestic frontiers to a world which is open without frontiers. And these are the changes now. Let us look at one or two more important changes that have also taken place that has contributed to the very significant dimensions in the study of law and their changes. And what is that? When you're talking about World War I and II, courtesy the great French Revolution and the emergence of the ideas of Marxism, Soviet Russia became what called a Marxist establishment in one of the major geographical areas of Europe. So we had on the one hand the Soviet Russia, and the other hand the Allied powers. And what happened was a so-called Cold War between these two camps. The Cold War produced a lot of, again, uncertainties in global relationships, and we have all kinds of global politicalizations taking place. So I'm not getting into all that in detail, but then by 1994, 1990, you find Soviet Russia breaking down. The breakdown of Soviet Russia also contributed to a great amount of changes in international legal thought and jurisprudence. And you find now two things happening. One, globalization, liberalization, and the free market as one major theme and the prevailing theme in social and political practices and economic thought. So the consequence of the breakdown of the Soviet Marxist establishment and the emergence of free market and globalization has again enormous implications for the study of law in contemporary times. If those of the students who are listening to me probably were expecting me to talk about, sir, how do I look at some textbook on jurisprudence? How do I look at what Supreme Court has said in Keshavananda Bharati, or what Supreme Court has said in A.K. Gopalan or Menaka Gandhi? I think I will come to it little later. You will find that the connection between whatever Supreme Court has done in all these matters is not done in isolation. No judgment of any contemporary court, apex court, happens in isolation, away from international, global, and other impacts and developments. Therefore, these are the broad, sweeping changes and aspects which have contributed to the changing dimension study of law in contemporary times. Now, with that, what is happening? So if you go back again to 20, 30 years of study of law in our law schools, law colleges, which are essentially departments of law in universities, and we were studying contract law, family law, probably somebody would have studied labor law or taxation. And remember about 20, 30 years ago, what a kind of study of taxation we would have studied labor law. We were all in the nascent days of a democracy. In the nascent days of a democracy, when we were studying law, we were still studying, or probably the study of law of England, right? The most of the law of contracts, most of the law of torts, were all foreign law to us. Now, maybe if you can count on your fingers, if you to count the number of judgments and tort law in our country post-independence, right? Without reference to any principles of English law, you will be disappointed. So we still fall back. We still fall back on English common law traditions in the study of law in many of the major disciplines. And so as one of the writers in comparative law, Alan Watson wrote about called legal transplantation. So legal transplantation has been happening over a long period. I want to just briefly mention about it for this very important reason, because we are talking about what happened in Europe, not probably looking at what happened in the Asian countries. No, it did not happen like that. Many of you are probably aware of a very catchy phrase called the Silk Route. The Silk Route was a phrase to denote the trade from Asia to Rome. So a long stretch of trade from Asia, that is India, China, and then trade across to Rome, was called the Silk Route. And people traveled all over to the great Roman Empire to do their trade and commerce, to Greece, to Rome, to all those parts of Northern Africa, to Arabia, etc. And then what did they carry with them when traders go? They carried with them their own traditions of law. So it happened in Rome, let's say, it has been studied and chronicled. A very noted academic in US called Professor Jeremy Waldron has written an important book on this issue. So when Rome was confronted with the question of how to deal with the differing legal traditions of people coming to trade in Rome, so Rome decided at some point of time that principles which are common to all civilized nations. In international law, there is a very interesting name for it. So principles which are common to all civilized nations, let us call them a corpus of law, and to be the corpus of law for resolving trade disputes in Rome, right? So that is again, in a manner of speaking, legal transplantation. So legal transplantation takes place by people carrying their own legal systems and getting it infused into a foreign country, or it takes place because of coercion from above, like colonialism. So legal transplantation has taken place both ways. But in contemporary times, legal transplantation is not due to coercion, but it is due to a social dynamic social forces. Somebody from a Marxist or a leftist point of view may say that we are still not so enchanted with the free market and globalization. There are a lot of social, international social ills which are the consequence of globalization. Probably students of law are also going to look at it, and that is another challenging study of law today. So then comes today. Today we have, let's say, if I'm able to talk to you without, being able to see you physically, I'm able to get across to you and transmit my ideas and share my mind with you physically, then comes technology. So it's not technology in a very light sense. Please appreciate that. For a generation like ours, the Dean will certainly agree with me. For a generation like ours, transmitting ideas and then sharing ideas with people was a more arduous task, in the sense you have to access physically books, textbooks, reading materials, then physically assimilate them and physically transmit them and then transfer them. Now, the physical necessity of transmission, of people moving across borders and then sharing ideas, is no longer a problem. So the ability to share ideas, the ability to be with you, across thousands of miles, what a wonderful thing that has happened to civilization and to human, inventions. So this technology derivative is taking us to certain realms beyond, maybe even 10 to 12 years before our own history or human history elsewhere. So the technology has brought in, has enabled us to use this tool as a more expeditious and far-reaching tool for the pursuit of search and knowledge. So the virtual world of communications has broken down several frontiers. So while therefore, if you put all of them together, so a 200 to 300 years of the movement of people, movement of ideas, emergence of ideas, philosophies, ideologies, social changes, very, earthquaking social transformations, that is building a socialist enterprise in Soviet Russia, its breakdown, and then what's happening today. So the students of law today are, I think, in a more open, broader world than what we were maybe even 20, 30 years ago. So the more the world is open and broader, I say the more are the challenges. In a closed society, the challenges were more, could be easily under control and regulation. As open the society becomes, as a society becomes without less and less of frontiers, and then the ability of human beings to regulate, to supervise, and to live in peace and order is also becoming an important challenge. So that is how I look at how the movement of the study of law has happened. Therefore, today, as students of law, you are again having one more important challenge to confront. What is that? So many of you would be obviously interested to hear from me, sir, after I complete my law, where do you think I can go and practice? Should I come to practice in Supreme Court, or should I set up a law firm and go and join a law firm? Or what should I do? Or should I become a bank employee or become an IAS officer, or probably enter into public life and become and float another political party because I'm a revolutionary and I think all these things that are happening in society are not according to what should be happening. Judge Posner talks about the brashness of the youth. Remember the word he used. He said, yes, that's all belong to the past. But I think when he said the brash of the youth, he was not using it in a pejorative sense. Youth has to necessarily mean the kind of energy which nature gives to us, both in mind and body, to be able to think newly and forever, vigorously and refreshingly. So when, as long as given that kind of a, gift of nature, I think you should not find fault with that. Therefore, when many of you are asking this kind of questions as to where you go and practice, I can give you a few probably broad roadmaps and not give you a textbook, right? In a lecture like this, or even in a personal interaction, I don't think there can be a textbook of guidance for students who are studying law today as to what can be their professional future. Like for a mathematician who studies mathematics, can there be a textbook on what a mathematician's future can be? For a person who studies science, right? A pure science, physics and chemistry. So you only expect to go to a laboratory and work as a scientist. You go to a university and a college and teach as a professor and academic. Therefore, there are very few opportunities open to students who study certain disciplines of knowledge. But I should say, there are no such barriers or frontiers to the student who study law today. Because now you can devise what your future can be. And what do I mean by that? Let me try to explain to you in the course of time. But before I do that, see, we were talking about how the confines of the domestic confines was looking at courts. So you will have a civil court, a criminal court, and the court is the only place where people who are trained in law will go and congregate. And then we have an adversarial system. And the adversarial system, then both you and me, right? You say what I know is the truth, and I say what I say is the truth. So both of us claim to be truth champions, right? So between these two conflicts as truth champions, truth emerges. That's why the court, drama happens. So all of us think court is the only place where study of law will lead us. No, not necessarily so. So today, the study of law serves a large number and diverse social needs and demands and necessities. So when somebody asks me about a critical analysis of the contributions made by national law schools, the 5-year school, study of law in the past. So National Law School from Bangalore is now virtually more than 30 years, right? So 30 years of a National Law School experiment in our country. What has it contributed to students, to lawyers, to judges, to courts, to government, and to society in general? So people say, from the point of view that, from a very traditional point of view, that when I study law, I must go to court and practice law. So if I don't practice law in a court, then where is that the study of law has taken me away from? So becoming a partner, setting up a law firm, and being part of the aid and advice to trade and commerce is not necessarily a component of study of law, has been a critical, point of view about the National Law School's contribution. So people say, even judges sometimes say, oh, what's happening to National Law School students? They go to law firms, they don't come to court. As if coming to court and becoming a lawyer is the only end product of being a student of law. I say no. Today, therefore, the study of law is not merely pegged to being a bird in the court. It is something which is vast and open. So most of you who think that I would like to become a litigating lawyer, you are not wrong. I'm not saying you are wrong, but just try to expand your own thinking on a relatively broader horizons. And when you think, are able to think on a broader horizon, then probably you'll be able to create a blend of your opportunities in your future career. The blend of opportunities are there for many of us to, to create, capture, and be able to even sustain. That's one aspect we must keep in mind. Now, I'll probably talking soon about how alternate systems of dispute resolutions were becoming more prominent at some point of time. All of us study the Arbitration Act, and both domestically and internationally, arbitration is said to be a very cheap, expeditious, and quicker resolution process for trade and commercial disputes and contractual disputes. And I was wondering why arbitration was not left alone. Why did the Indian Parliament enact arbitration, conciliation, and mediation law? So where is the connection between arbitration, conciliation, and mediation? And why should conciliation and mediation be at all in the domain of law? If you say that your truth is in conflict with my truth, whether in the civil law or in criminal law, and this conflict between two truths and claim to truths can be resolved better and profitably, advantageously only in an adversarial system, then it is the court which is the only place where everything can be resolved. So where is conciliation, where is mediation, and what is the importance of arbitration? I think you need to think on this. So the relevance, so the advertence to conciliation or mediation is not merely a panchayat, idea. It is something broader than that. Because the complex contemporary social problems have become. Now let us take a few illustrations and see how they are complex. As students of constitutional law, all of us know we have fundamental rights. And the prominent fundamental rights revolve around what? Freedom of speech and expression, right? The right to liberty. Then the most important thing is happening is what? Can anybody guess apart from right to liberty and freedom of speech and expression? So we have other constitutional rights in Article 9, 15 and 16, right? The right to be able to participate in public employment and services. So we have the issues of reservations. We have the issues of, right? So we have these issues which can we resolve all these issues by through conciliation and mediation. Suppose tomorrow, if the parliament were to enact a law saying that I'm going to bring down the percentage reservations for scheduled castes and scheduled tribes, because according to a national census and study, there is enough creamy layers in scheduled castes and scheduled tribes, that way you're going to bring down the concept of reservations. So can you have a conciliation and mediation to resolve this problem? So people would obviously jump to an Article 32 petition to challenge such kind of a law. But still we need to look at the ideas of mediation and conciliation in a more expansive way than mere problem solving between individual disputes. I think it's important for both academics and students of law to look at these very complex challenges in our contemporary society, where caste, right, other social hierarchies, and access to health, education, right, and material resources, opportunities in public employment, these are all very complex problems. And nobody can say, I have like a magic wand, a solution which everybody will accept. If only we can discover such easy solutions, I think we need not study law at all. We can only go for study of such magic solutions. And I don't think they're so easily available. But I think by a perspective expansion, the idea of conciliation and mediation, and moving away from relatively from the adversarial system, we can still discover those magical solutions which can bring about a more harmonious, less contentious resolution of these very complex, conflicts. And that is where the idea of conciliation and mediation within this complex domains will have to be built in. Can we do that? Can we think of those lines of thinking in the context of the complex social conflicts? I think it is possible. So far, we have not paid close attention to it. We have looked at conciliation and mediation as only some kind of a distant cousins to court practice and court litigation. I think they need not be distant cousins. So you send students of law to a court mediation program or a mediation programs in some camps, where they learn the art of mediation. But then it will die very soon, because when you go out into the open world and become a litigating lawyer or enter a law firm, these ideas will slowly vanish. And vanish because you will be in the thick of pursuing your livelihood and more mundane callings in your life. That's why it's important while you are a student of law, as best as possible. So I remember an eminent academic who was shifted from India to US. He used to call law schools as R&D laboratories, research and development laboratories. So I think today the study of law is like a R&D laboratory. So if you clearly catch up with this idea and be able to comprehend how the study of law is essentially both individually and at the collective level in the law school is an R&D laboratory, then you will begin to find that the diverse and various unexplored opportunities for professional career will be there for you. Just as you can convert law school as an R&D laboratory, I think as lawyers collectively and individually, we can convert our professional practice itself as R&D laboratories. There's a very dynamic movement. It has to happen. But how do we think about it? We need to start at least thinking about them. I think moment and idea, the germination of an idea lies in a dogged pursuit of that idea. You pursue an idea. I mean, look at that man called Columbus. Columbus wanted to set out on an expedition. He thought he will go and land in India, but landed in America, right? But then he went on. How many times the Columbus went across the Pacific Ocean? 14th century, 15th century. What kind of travel aids were available at that time? No, GPS, right? So without a GPS, Columbus could discover America. If that is so, why do we need any other GPS except the idea that we need to transform the study of law and the practice of law into practices which are closer to social needs, social necessities, and social transformations. I think that once that idea gets sown into your mind, it begins to slowly germinate and can become a transforming idea. So these ideas are possible. And while I'd certainly love to talk to you about, for instance, it's a very engrossing, engaging subject to talk to you about how we look at the idea of constitution, particularly in our own country. The dramatic changes that have taken place in the past 20, 30 years through what Supreme Court has been through the idea of constitution and the use of constitution as a social tool, as a social transformation tool. I would definitely like to talk more about it. And probably the way I would like to talk about it is to receive questions from you. And that's a very engrossing, a very inspiring story. And I keep telling students also that whenever every day I enter the court and come out of the court after my day in the court, the issues we handle in the court are not mere private disputes. They're not mere disputes between two sets of people where somebody got monetary compensation, somebody got an appointment, somebody got an alimony, right? Somebody got a home or somebody got a home back, whatever it is. They're not merely private disputes. They symbolically represent the fabric of issues happening at the national level, at the social level. So every day in the court symbolically represents what is happening in the social fabric and what is not happening there. So what is not happening is happening inside the court. So what should happen in society, because it does not happen like that, is happening inside the court. So if both of you and me, are able to resolve a dispute in a friendly manner by throwing each other's arms on our shoulder, then why do we need a third party as a referee or a court or a judge? We don't need them. But that's what's happening in our society. No society can say that we are free from conflicts and disputes. But the idea is, if every society will have to move from one set of conflicts and disputes to a different set of conflicts and disputes, Now, the ancient Indian social order before the British came had a different set of social issues. Nobody ever thought that, say, look here is a hierarchical social order based on caste or religion or whatever it is. I'm not getting into those details. So that was entirely a different set of issues in our traditional social setup. But along with colonialism and globalization, etc., that old set of traditional issues got been submerged and become part of some other set of social issues. So it gets transformed. But social disputes and issues continue to be, unfortunately, they continue to be part of human history. And then what are those people who want to bring about social transformation, desire, and then dream? They think, can we have a society where there are no disputes at all? When you talk about social order and peace, what do you mean? We mean that as far as possible, through instruments of law, through social persuasion, through dialogues, through personal interactions, our conflicts which arise because each one of us wants something different from the other, right? So get up in the morning, I want to brush my teeth using, let's say, a particular brand of toothpaste. My mother will say, don't use that, right? So go up in the afternoon, I want to go to a particular friend's house and then go a particular and come back only late in the evening. My father will have a problem about that, right? So two of us are friends. I want to go to one movie and you want to go to some other movie. You want to go on a vacation. You choose one place, I choose another place. We have from a friendly disputes to disagreements, we have serious disagreements in several issues of aspects of life. Then therefore, the small personal disagreements, we don't need a lot to come in, right? But when it comes to grow bigger and bigger, where the conflicts become more intense, law necessarily comes in. So today I'll ask you a question. Is there any aspect of our life today, where law has not entered into? Can any of you tell me there is some aspect of life which law has not entered into? The only aspect of life which law has entered into is my own mind, right? Law will not tell me how will I think. Law will not tell me how should I write poetry. Law will not tell me how do I become an artist. Law will not tell me how to become a painter. But after I have painted, right? After I have thought, right? After I have written a piece of music and I want to share it with somebody, then law comes in. Your copyright, right? Your intellectual property rights. And then when you want to walk out into my neighbor's land on a quiet evening, your private garden, I don't want him to see me walking into the garden. Then there is a question of trespass. It's my private desire, right? So law necessarily intrudes into a major segment of our lives today. Why has it happened like that? I think a serious student of law will have to also contemplate on this. So therefore, do we think a study of law today on the idea of a constitution and all those ideas surrounding it, right, should move away from a conflict-ridden study of law to a study of law where, as I said, John Adams, my grandchildren will be studying poetry and music, architecture and pottery. So where do you want to go? So these are important, questions which a student of law will have to keep asking, repeatedly, every day, day after day. And that is how you will personally guide yourself as to which will be your career path. Every one of us ultimately, whether you by fortunes of your, parental position in society or your social connections or luck or destiny, pick up any of these ideas, right? You may be able to land somewhere sooner or than later compared to others. Maybe somebody who is lucky will become a judge at the age of 43 or 38 even. There are many judges who become High Court judge at the age of 38. So they are lucky ones because they have family connections, right? Many of us do not have all the family connections. But many of us have an idea of equality, right? All of us think equality is an important social idea. As we are talking about Articles 15, 14, 16, then all of us must have equal space in public life. All of us must aspire to have same kind of opportunities in professional career. So how far is possible? But can we not create such equal opportunities? So when we talk of equal opportunities in the professional career, don't look at it in a mechanical way. look at it in a more dynamic way. And what do you mean by that? So don't look at merely an opportunity available yesterday as the only opportunity available today. Then we are in a narrow compass. We are talking about creating more opportunities, then the equality problem will slowly disappear. Disappear into a very narrow area. But today, since we have left most of our opportunity creating initiatives in the hands of the state and government. And I think today it's important for law schools and universities to take over this job in a major breakthrough and collaboration with students, engagement, that how we can become the centers of creation of new opportunities in for all kinds of professional careers. And why should it be left to governments and policymakers alone? So we can create our own opportunities. How do we create them is a different question altogether. But I only wanted to share with you this idea, which is a very challenging idea, but it must be an engaging and absorbing idea. With private enterprise were translated into formal constitutional limitations. So the exchange of idea is what it's talking about. The exchange of idea between a lawyer and legal academic and a court, and how a constitutional landscape transformation can take place. Now, a couple of more quotes. Now we're talking about the sweeping changes in legal education. One of the greatest figure, again, like Professor Madhav Menon, is Professor Bakshi. Now, Professor Bakshi wrote a couple of decades ago on the legal education scenario like this. I have two quotes which I want to read out to you. One is this: the traditional conceptualization of the law in the common law world is largely in terms of judicial process. Such conceptualization leads, though not necessarily, to isolation of legal processes from social processes and purposes. We have no problem of an overly technocratic legal education as the advanced countries have. Rather, we have an insufficiently technocratic legal education. So, if a sound technocratic legal education is socially relevant, let us first seek to provide it. He wrote it about 20 years ago. Now, another following quotation, following little later thereafter, he said, talking about law teachers, it is true that by and large, the Indian law teachers expounds on a topic completely alien to the existential experience of the students. Have you ever paused to wonder, when teaching private international law, how a student in Gorakhpur, Indore, or Rajkot can take a serious interest in the mysteries of Indoika versus Indoika, involving sect nationals, Polish divorces, English remarriages, and diverse petitions and decisions of English courts in such and related situations. What Professor Bakshi was talking about is the colonialization of law in our country and the decolonization he was talking about. To put it in simple terms, I think the decolonization has been taking place over a period of time. And that's why we look at our law schools as R&D laboratories where despite globalization, despite legal transplantation, despite your, the inability to, or probably the difficulties in resisting these global impacts, despite all that, we need to decolonize our minds on certain deeply rooted ideas of the study of law and ideas of administration of justice. And I just want to quote from an important book written by Professor Duncan Kennedy, and then I'll conclude my talk for the day. So Professor Duncan Kennedy belonged to the Harvard Law School. He wrote in the year 1982, and this is how he talks about legal education and the reproduction of hierarchy. I quote, "Law schools are intensely political places, in spite of the fact that the modern law school seems intellectually unpretentious, barren of theoretical ambition or practical vision of what social life might be. The trade school mentality, the endless attention to trees at the expense of forests, the alternating grimness and chumminess of focus on the limited task at hand, all these are only a part of what is going on. The other part is an ideological training for willing service in the hierarchies of the corporate welfare state." So Professor Duncan Kennedy was talking about what American law was doing in the American corporate structure. Of course, a lot of critics who disagreed with Professor Duncan Kennedy, but I think he was, in a way, capturing the US realities. Therefore, today we have these developments, and to conclude on a sweeping note, let me say, so nation states all over the world, whichever is a state, including communist China. So many of us do not know what's really happening inside communist China, but except that COVID-19 has come from there. And but if you can go closer to communist China and study it, there are opportunities for studying it and comparing it with what we cherish in our own constitutional domain as the right to an open society, the right to be a freedom-loving citizen, and the rights and the grand things which flow from the right to liberty, right? So all nation states bear the brand of globalization today. Nobody can do without it. And but then what are the problems? Climate change and the ramifications, transnational trade governance and a silent transfer of sovereignty to international institutions, multicultural jurisprudence, then the intellectual property and the human rights dialogue challenges, which are not what exactly they were 50 to 60 years ago. Because, as I said, you talk about the transmission changes in technology. It don't happen only in the internet and the webs. It will happen in the rest of the, in the domains of science. Now, medical science, advances in medical science, advances in nanosciences, advances in, for instance, in the physical sciences, have taken us, far, far beyond what we were about 56 years ago. And with every discovery in science and invention in technology, we face a challenge. What's the challenge? Regulation. So a scientist who discovers a scientific idea will not just keep quiet with it in the laboratory. It must be shared with the rest of the world. For what purposes? Suppose if Newton discovered that if a fall of an apple brought the idea of gravitation. So we need to know what is the importance of gravity. So it is not merely a pure theorem which we can discuss on a dinner table or across the television channel, right? So it has a utility component. So whenever utility component comes in, then we are confronted with the question of regulation. So how do we regulate modern technology and science? So therefore these are the emerging frontiers of the study of law, if I put it like that. So that I think should be probably sufficient for my very what called thickly, densely, placed discussion with you to probably like to be open for some kind of questions, and let us see how far I make through a question and answer session what I spoke with you in this quick what called transcription of the study of law over 200 to 300 years. So I am sorry, I must have packed in a lot of things. I want a student of law to know at least a glimpse of what my thought process has been. So even if you get a glimpse of it, I only wanted to be able to tell you, please pursue, keep pursuing every bit of the idea, or at least 1/10 of what you have listened to me today. Pick it up on your own level, right? Go into your own private, domains, not necessarily in the law school confines. And wherever you think you have time for a reflection, think about what we have been talking today. And I think ultimately, a student of law is the most prized citizen in a society. You are the most prized citizen in a society, apart from people who contribute to science and technology. Everybody else, whether in public life, whether it's the prime minister or the president, whether representatives in the parliament or otherwise, they're all people who would ultimately depend on what's called the prized segment of society's contribution to social welfare and social order. So you are a prized segment of society, and there is a value placed on this prize. And how will that value come about? It is by your own initiatives. It is not by an external evaluation. The value of the prize which you will carry about your own self is what you will create by your own self. So the prize which you will carry, to repeat, is what you will create for your own self. Except that, of course, many of us are endowed with some element of intelligence different from others. Forget about all that. Don't worry about that at all. I may be 90% IQ more than you. Does not matter at all. But your 10% IQ can create more wonders, right? The question is, how do I capitalize whatever I have, God has given to me, whatever nature has gifted to me? How do I capitalize them? And what do I do with capitalization? I capitalize for my own satisfaction, for my own fulfillment. How do I live my life as a lawyer or a law teacher or a legal academic, or playing any part, through the study of law? What do I do with the fulfillment in my life? That's very important. Right? Ultimately, all of us, if we're going to bed, want to lie down on a bed on a very comfortable, day spent. We want to know that, yes, today has been a beautiful day, and I have done something very good. And we want every day to be like that, isn't it? So we teach our children like that. What is this? When grandmothers give stories to children, that is to make them go to bed on a very comfortable mental level, isn't it? So the grandmother's stories, today we're talking about some grandmother stories in a different language. So let us catch up with some of these grandmother stories and try to translate them into a personal life as best as possible. Now let me conclude with that note. Is that fine?
All right, sir.
Very well.
Thank you so much, sir. Thank you for such a wonderful, insightful address. So, sir, we are right about out of time for the webinar. But if you permit, we would like to at least pose one question to you.
No problem.
Right, sir.
Whether a question from you or
Sir, from the students, sir.
Yeah, please go ahead. Go ahead. Please go ahead.
Sir, is there a checklist for law school that a student who is pursuing law should do while studying law? Is there any checklist that you feel there is?
Not a very difficult question, but the answer can be a little difficult, right? In the sense, let me tell you what I did while preparing for a lecture like this. I was trying to find out what does a student to do about a study of law in some foreign universities. So go on Google. Now just say challenges in the study of law. You will gain a lot of comments, articles, and statements there. So one thing which has been repeatedly stated wherever it is, somebody said, beware, when you are a student of law, you are in for any number of hours spent on studying, right? You are going to study and study and study and nothing else study. Beware, right? So there is something very interesting there. So why is there that? Because when you study law, unlike you study, let's say, you are a student of, let me give this examples. If you're a student of mathematics, what happens in your mind? The mind constantly gets engaged in the pursuit of mathematics. Mathematics is a very challenging thing in human civilization. Many of us have heard about the mathematical genius Ramanujan, right? So Ramanujan belonged to a small time town in Tamil Nadu. And then he was not a teacher. He didn't have a place where he can go and share his mathematical ideas. He used to go to the railway station and then write his equations on the, carriages which used to be stationed there. And somebody caught a photograph of this, a teacher in some school, and said, what is this? Something wonderful is happening here. And they shared it with an English mathematician in England called G.H. Hardy. So Professor Hardy looked at in wonderment and said, here is a genius lying in India. So it was Professor Hardy who brought him into England. And he became famous in the world thereafter. So why I want to draw this example is, whenever your mind is fully engrossed in the pursuit of anything, right? In the pursuit of anything noble and absorbing to your mind, I think you will not worry about other things at all. The study of law is one such pursuit, right? You don't only sit in the library and study law. You only don't sit on the internet and study law. The studying law, they said, is studying human life, right? So wherever a problem arises before you, study it properly. And study it properly without the instrument of law and also through the instrument of law. So that is one lesson which I will give to all students of law. Whatever problem comes in front of you, right? If there is a problem, just look at it as a problem. Don't bring in your knowledge of law. Look at it simply as a problem, right? Now, suppose an art piece is before you. If an art critic is not there, you will only admire the beauty of the art. But an art critic comes and tells you, oh, this is how this artist did it. This is the meaning, this is the tradition behind it. Then your mind is only full of the ideas about what has happened there, but not about beauty, right? So when you read a piece of poetry, you won't read Shakespeare. Just read Shakespeare or Kalidasa. And then you can read it simply and be pleased with that. But somebody were to give you a commentary on Kalidasa and Shakespeare, then you know what is meant by this word, whether it's an old English word or a new English word, whether it's Sanskrit or Pali, all those kind of things. So isn't it? Therefore, when you look at a problem, anything across you come across, look at it firstly as a problem, then look at it later as how law looks at it as a problem. Then find out how law fails to deal with the problem. Then ask the question, why law fails to deal with it as a problem. So then every question, you'll keep on asking questions like that. So that is where, while there is a comparison between thinking like a mathematician, there is, and a lawyer thinks slightly differently with a mathematician, right? Because a mathematician is confined only to a problem in mathematics. Like by studying a problem in mathematics, we're not studying to know how to make a cup of coffee or a cup of tea, right? But when you're studying law, we want to know how to make a good cup of coffee today, so that we can get a good brand which is free from intellectual property crimes, right? I don't buy a coffee brand which somebody said it is either a patent law is violated and therefore I don't get it, or the wrapper on it is a problem, or the taste on it has some issue, right? All kinds of issues are there. So that's how I think you keep asking questions, endless question asking. That's what Socrates was doing, no?
True.
Right.
All right. Thank you so much, sir. Thank you for such a wonderful answer. So with this, we will move to the end of the event for today.
Okay.
Okay, sir. So to begin with, I would heartily like to thank you, sir, for sparing time out of your busy schedule and delivering such a productive and knowledgeable address. We are truly very, very enlightened. I would also like to express my profound gratitude to Dean, sir, and especially to Bhavesh, sir, who endured and had patience for our technical faux pas in the beginning of the webinar today. Thank you so much, sir.
How
And I
many
would also,
students
yes,
there?
sir. Sir?
How many students are there around?
Sir, when
How
the
many students are
webinar began, sir, we had close to 212 participants. And that was a mixture of both students and faculty members joining all across the country, sir. So
Oh,
I
I
would
see.
also like to thank Durga ma'am
Very
and the student coordinators Garvita, Harshita, and Manogya for assistant in the smooth conduct of this event, and Mr. Kush Kalra for helping us organize this event. But most
I don't see
importantly,
him.
Kush sir, if you could please switch on the video, sir.
Yes, sir. I'm here only, sir.
Yes. Why are you invisible?
Sir, I'm here only.
All
Okay,
right.
go ahead. Please go ahead.
Yes, sir.
Yes.
And I would lastly like to thank all the faculty members and participants who wonderfully sat today throughout the event and participated so actively. Thank you, everyone. Thank you so much, and
Right.
we conclude the event. Thank you.
We'll try to meet in the physical world very soon.
Hopefully, sir, and very soon. Thank
Right.
you.